places, Sergeant.
They send help out.
Yeah, they needed two to do my job. I've been trying to get another one for a whole year. And I'm just like, no, it's not okay.
Thank you. Have a seat. Good afternoon. As you all know, I am about to announce the verdicts as a result of the bench trial that took place last week. Before I do that, let me just say that this is an incredibly difficult case. Not just because of the catastrophe that happened or who it happened to, but also because of the conflicting evidence and the gradations of responsibility that the law imposes. Let me just briefly discuss the counts. 26 counts in total. Counts 1 through 6 charge the defendant with aggravated vehicular homicide with respect to each of the 6 fatalities. Those counts charge the defendant with recklessly operating a motor vehicle causing the death of another person. Counts 7 through 15 charge the defendant with vehicular assault. In each of those counts, the defendant is charged with causing serious physical harm to another person as a result of recklessly operating a motor vehicle. Counts 16 through 20 all charge the defendant with assault. These charges are based on the assertion that the defendant knowingly caused physical harm to another person. You know, this job gives me the opportunity to recognize how at various points in our life we're all just a few feet or a few seconds away from a disaster. And that's what happened here. The facts of the case are largely undisputed. November 14, 2023, between 8:47 a.m. and 8:48 a.m., a fatal crash involving 5 vehicles occurred on Interstate 70, approximately 0.2 of a mile west of milepost 119 here in Licking County. At the time of that collision, traffic had slowed due to a crash that had occurred approximately 1.5 miles ahead. There's no dispute in this case that the 2019 Freightliner driven by the defendant struck the rear of the vehicle in front of it. That vehicle was pushed into the rear of the vehicle in front of it, and so on. Counts 1 through 6 and 7 through 15 all allege that the defendant acted recklessly in his operation of his vehicle, and that reckless operation caused the death, as alleged in counts 1 through 6, or the serious physical injury, as alleged in counts 7 through 15. Recklessness is defined in Ohio law as follows. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Negligence is defined as follows. A person acts negligently when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that the person's conduct may cause a certain result or be of a certain nature. A person is negligent with respect to circumstances when because of a substantial lapse from due care, the person fails to perceive or avoid a risk that such circumstances may exist. I find that Mr. McDonald is criminally responsible for this accident, this collision. However, I find that the state has failed to establish beyond a reasonable doubt the element of recklessness. There was a lot of argument and evidence centered around the data from the defendant's cell phone. Frankly, I did not find the evidence regarding the data from the cell phone to be convincing. Because I find that the state has failed to meet the element of recklessness, I'm going to enter a not guilty verdict on counts 1 through 6 and 7 through 15. However, I will enter guilty verdicts on the lesser included offenses to counts 1 through 6, which are vehicular homicide, violation of revised code section 2903.06 A3A, which is based on his negligent operation of the vehicle. Counts 7 through 15, frankly, they're based on a higher mens rea or mental element than even recklessly. And because I find the state has failed to establish the element of recklessness, the evidence is insufficient to establish that he knowingly did this. All right, I anticipate that the parties would prefer that sentencing be scheduled at a later time in order to make sure we comply with Marcy's law. Is that correct?
Yes, Your Honor.
All right, then I'll schedule sentencing at a later time. Bond is revoked. Do counsel have anything further at this point?
Yes, Your Honor, just for clarification, the vehicular assault charges are 9 counts of those are also, you're finding negligent on them, those charges, as well as...
I find that he acted negligently at least, but are you suggesting there's a lesser included offense based on negligent operation and physical harm?
I'm just asking if the court is making that finding on... No, I'm not. I'm just asking.
Okay, yeah, it's not guilty then on counts 16 through 26.
Thank you, Your Honor.
All right. Thank you.
So, Mr. McDonald.
Yes, sir. Yes, he decided that he was not reckless. He's guilty of what he found is vehicular homicide. That is a misdemeanor offense. Not there. It's not a lower one of those. Yes.
So the lesser
It surprised me in terms of, we believe that we presented sufficient evidence. We believe we presented sufficient evidence to find him guilty of all charges. We disagree with the verdict. That's the judge's province to make. He is the trier of fact.
It's a bench trial, not a jury trial.
Were you surprised at the judge's decision?
The judge's decision is the judge's decision. It's within the gambit of what he could decide. What I can tell you is this. I want to thank the Ohio State Highway Patrol, the hard work that they did, especially Sergeant Trevor Jasper, Trooper James Coughlin, also Trooper Sean Grimm. The patrol's work in this case was fantastic. I'd also like to thank the people from Tusky Valley who have suffered an absolute disaster on November 14th. The verdict is the judge's. The verdict belongs to the judge. We disagree.
If the phone had not been destroyed, would that have changed things?
Well, there obviously be more evidence, but the phone is independent of whether or not he was reckless. Again, that was our opinion. That's what we outlined, that there was 3 different ways that we believe that he was reckless. And so, again, we disagree with the judge's ruling. That's the judge's province to do that. And we believe we presented sufficient evidence for convictions in all charges.
Do you have any regrets in how you presented your case?
No.
What does this do for the families who were thinking they would get more out of this than misdemeanor charges?
Realistically, our system is one based on law and based on facts. Juries decide cases, and in the absence of juries at the election of the defense, they can request a bench trial. That is our system. We respect the decision of the court. That is our system.
This has been a long process for the families. I know you've been in constant contact with them for the last year and a half, pretty much. What conversations will you have with them leading up to sentencing?
Conversations that I would have with them is something that I probably will not discuss with the media. It's just because, again, they suffered a tremendous loss. It's an incalculable loss. And, unfortunately, the system didn't serve him in this particular case.
Why do you think it was reckless?
You were sitting through the same trial I was.
I was not.
Well, I would refer you to my closing arguments. I would refer you to the evidence we presented. We disagree.
Reckless because there was evidence that he was on his phone, reckless because he didn't slow down, reckless because he was speaking.
Yeah, I
How would you sum it up?
I think I covered that in my closing.
I get that,
I
but
think,
I wasn't here, so I'm just trying to look for a summation.
well, I don't know that I can in 10 seconds, but the best I could probably do is tell you that if you close your eyes for 7 seconds and you're carrying 50,000 pounds of weight down a road, moving 105 feet a second, and you don't see anything in front of you, so much so that when a picture is taken of you, when you're not expecting it by a witness and you have your hands up in the air and you're completely oblivious to what happened, you're probably reckless. So we disagree.
We could hear the family's reaction to the verdict, but on a personal level, I'm wondering how you feel.
I don't feel good. I mean, this is one of the consequences of all trials. So we accept the court's decision in this matter, and this is the system that we have.
Did they set a sentencing date?
Not
No.
yet.
Sir, some of us were in the hallway when you began this media gaggle. What was your initial reaction to your overall reaction to the verdict today?
Disappointed.
Is this closure for the families, or what do you do now?
I don't think that when you bury 6 people and you have a number of other people who have suffered serious harm, life-changing injuries, that there's going to be closure. I don't think that any verdict in this court would bring closure to the severity of loss that these people have suffered. I think at the end of the day, the process itself is part of the healing, but it's not the conclusion of the healing. It's just you can't sum up their loss in any words.
Do you think there's one thing in particular that hurt the case, that prevented the guilty on the felony version?
Every case comes down to the weighing of the evidence either by a jury or by a judge. And the verdict of every case is decided by that. And so in this particular case, the judge felt that the evidence wasn't sufficient to sustain that standard. In the position that he was in, that's his prerogative to do.
Spell your name for us, please.
Murphy is the last name. what I will say this about Judge Branstool, I've known him for 8 years, he's a good man. I think he's a man of integrity, and I think he's fair. I think he's a fair judge, I think he's a good judge.
And first name, we're from Cleveland, that's why I don't know.
Oh, first name is Clifford, Clifford.
County prosecutor or prosecutor?
Assistant prosecutor.
Okay, thank you so much.
Thank you.
Sir. Thank you.
So,
They just need to talk to Cliff for a little bit, and then they'll talk. They just need to ask some questions because we couldn't hear everything. So I apologize.
just to be clear. That's what I wanted to ask you. I haven't sent anything back yet.
Yeah, I didn't know if you were. Nobody wants to. So I didn't.
Sentencing is still a ways away. What's your strategy going forward with the sentencing?
Well, in Ohio, you can't be any longer than 18 months of local incarceration for the state. I would anticipate it will reach that limit. How it gets carved out on the different charges, I'm uncertain. I would anticipate 18 months.
Chris, thanks so much for your time.
Thank you.
So we're out here in the hallway, as we just get our reactions
So they can be consecutive. Well, so in Ohio, the maximum for a misdemeanor first degree is 6 months of local incarceration. So that can be consecutive, and I would anticipate they would be to account for each individual that lost their life. However, in Ohio, there's also an 18-month maximum per statute of local incarceration.
So he can only get anywhere from 6 to 18 months. If he stacks them.
Theoretically, yes, but I would anticipate somewhere around 18, yes.
Could you obviously you were hoping for the best outcome. Is this what you were hoping, expecting the judge to say today?
Yeah, again, I said before, I don't think there's any winners here. It's a tragic set of circumstances. There's 1.8 terabytes of data that we went through related to this case. I think when you look at the facts, it was an absolute tragic accident. The judge read the definitions of recklessness and negligence into the record, and if you followed the proceedings, the negligence fit. So I respect the decision.
Did Mr. McDonald say anything to you after hearing that verdict?
No.
Do
No,
you
we
expect
talked a
he
little
will?
bit prior to. Yes, I'll speak to him before sentencing. So.
What do you have to say to those families who think this verdict is not enough?
I understand the pain. I do. Again, I have teenagers myself. I can't even fathom that sort of loss. We tried this case within the confines of the law. Everybody's entitled to the best possible defense, and we did our job the best that I possibly could. So.
Were you shocked to hear the judge's announcement verdict?
I wouldn't say shocked, no. Again, Judge Branstool is, an incredibly smart guy. He's been a judge a long time. He's very fair, and that's why strategically we tried this to the bench. We wanted him to make that determination. I felt strongly that the negligence fit, the definition of it, as opposed to recklessness. Recklessness is a very high standard. So that's why we strategically tried it to the bench.
And for those of us who aren't attorneys, can you explain the verdict for us?
Yeah, so the negligence verdict means that the lesser included of, it's still vehicular homicide, but it's the lesser included, which is the misdemeanor level, which is punishable by a maximum of 6 months of local incarceration or up to a $1,000 fine. At a felony level, if the reckless standard had been met, then it's a felony in the third degree, which is punishable by a maximum of 36 months in prison and up to $5,000 fine for each count. So really it was night and day. I can't remember exactly, but I think 31 years, I think, was the maximum total for all the counts. And then, as I stated previously, regardless of the accounts on the misdemeanor, there's a 18-month cap on local incarceration. So.
And you think he'll get the 18?
I would anticipate it. Obviously, we'll argue for something else, but I would anticipate it.
Does that include time served?
It does, yes. He's been in for a little over 10 months at this point.
So if Judge Branstool sentenced him to 18 months, he could be out in about a year.
Probably another 7 months, somewhere around there. Yeah, 7 to 8 months.
I'm not sure if you're representing Mr. McDonald in the civil trials, but how do you think this will impact those litigations?
I don't represent him in that, so it's really not my forte, so I wouldn't comment on the civil trial.
How was your client, where was his mindset throughout the trial last week?
I think he's devastated. In all my interactions with him, he regardless of what today's outcome is, I think that he personally knows that he was a proximate cause of these deaths and injuries, and I think it's devastated him personally. So I think that he showed during the trial. I think he had his head down a lot, and I think he just hearing the facts took a toll on him.
Why did you decide not to call him to the witness stand?
Well, he didn't remember the last. I think it was about 5 to 6 minutes. So, and that's the crucial time period. So it was really, unfortunately, nothing he could offer us, other than that morning, which really wasn't disputed, that he'd gotten his truck at a certain time, and so there was really no benefit to that.
Does he plan to give a statement at sentencing, say anything to the victims' families?
Undetermined at this point.
Thank you so much. Thank you, sir.
Thank you, I appreciate it.
Thank you. Nice to meet you.
Thank you, I appreciate that.
Does this make sense?
anybody that wants to speak should be out shortly, but everybody else, I think, just wants to. This is Danielle. Danielle. Okay. Straight right up. I think everybody else is just go here. Here's the elevator. Here's the elevator. Here's the elevator.
Yep, we can. You know, and that's what the defense attorney knew going into this trial. That is why he asked for a bench trial instead of a jury trial, because a judge thoroughly understands the law and has to base his verdict off the law, when sometimes juries can be swayed by the emotion of 6 people who were killed in this crash, 3 of those just students, teenagers. And so Judge Branstool made his decision today. He said in his opening remarks how tough of a decision this was for him personally. He knows the emotions of this case, but he has to decide based on law. And what Judge Branstool said was it came down to the evidence, or lack thereof, conflicting evidence about Jacob McDonald's cell phone. Now, that cell phone was burned up in the crash, so it was never recovered. However, they were able to get the data from his phone, but AT&T will not give the prosecutors, will not give the defense attorney the exact data that was used at the time of the crash or the minutes leading up to the crash. We just know about 40 megabytes of data were coming and going from his phone in the minutes leading up to the crash. But the defense attorney argued that that doesn't mean it was in McDonald's hand, and that that's why he ruled that it was not reckless. And the judge obviously agreed with the defense in this case. Some of those victims' families have been here. They've had a long haul. Kevin is with them now. Oh, I didn't know they were right behind me.
No rush. Obviously, a lot going on. Just thank you for everything.
You know, right? I got everything to see at the car.
Yep.